Welcome, everyone. Before we begin this webinar, I'd like to go over a few housekeeping matters. Questions are welcome. Please use the Q&A feature at the bottom of your screen and not the chat feature so we can make sure and catch your question. Answer the questions as we go along, and we can just have you participate through the Q&A feature, so please do that. Another thing, you have to stay for the entire hour in order to get Utah State Bar CLE credit. If you have to sign out and you sign back in under a different name, please email me and let me know that so that I can make sure you get credit. If you sign out and sign back in under your own name, it's fine, no problem. We'll catch that and make sure you get credit for it. Now, it's my privilege to be able to introduce to you Robert Harrison from Stilling and Harrison Healthcare Law. He was going to be joined today by Bill Stilling, who is a U-Law graduate and was in fact my classmate, but Bill is under the weather today and not able to join us. So the entire burden of this presentation is going to be on Robert, who wishes he was a U-Law graduate, but isn't. He did get here though in the end. So Robert, thank you. And I'm gonna throw it over to you to begin this presentation on old wine in new bottles and what we do with healthcare privacy.
Thank you. It's so nice to spend some time with you. I want to confess something up front. I am a pacer. I love being in live classrooms and presentations, and I'm feeling constrained. I've done quite a few Zoom presentations now over the past year, and I'm still very uncomfortable with it. So if I seem to be a little bit uncomfortable, it's because I'm a little bit uncomfortable. I want to get up and look at you and talk to you and walk around the room and share with you in that way. We will do the best we can here. However, I want to underscore what Lori said. I am delighted to pause anywhere along the line to address any questions that you might have. And it may be that some of you know more about some of these things than I do. So please don't hesitate to make this as interactive as we can make it. And I want to, I just talked to my dear friend Bill Stilling literally about 5 minutes ago, and he wanted me to express his regrets for not being able to be with us today. I had with Bill a very interesting history when it comes to HIPAA, and so this would have been very appropriate for us to be doing this. This would have been something of a 20th anniversary for us. The first privacy legislation, or the first legislation that was specific to privacy, was of course HIPAA. That was passed in 1996 and did not become law until December of 2020, or at least the regulations took effect in December of 2020. And starting in 2021, Bill and I did a series of presentations on HIPAA. We did some for the bar, we did some at the med school, we did some for, I've forgotten, there were two companies who were very big into sponsoring CLE presentations. And so we had the privilege of doing several presentations together when HIPAA was still quite young. And so on behalf of Bill, it's nice for us to be doing this again in sort of a 20th anniversary. I also want to share something more personal. In 1993, in the fall of 1993, I packed up my Jeep Cherokee and pulled out of Salt Lake City, going back to Washington. I had an opportunity to do a health policy fellowship in the 1993-94 year. And I was working in the Senate. And the first assignment that I got when I arrived in my cubicle was to work on some prototypes for legislation that would address the portability of health insurance. And I looked at that and said, what in the world are you talking about? The idea was that there was something called job lock. And the job lock concept was that people would stay in jobs that they probably should have left in order to advance their careers. Because if they left their job, they wouldn't be able to carry their health insurance with them. So they, because of health insurance concerns, were locked into jobs. The concern was that that was impairing mobility and was stifling innovation and creativity. And so there was a lot of interest in passing some legislation that would allow health insurance to be portable, notwithstanding the typical deference to states in the regulation. And so I was asked to begin work on that. And I spent a significant part of the next several months working on that. And so it is literally true that I started working on HIPAA before HIPAA became law. And it was interesting to watch the transition after I left Washington, of course, which was before the statute was enacted. So I literally have been with this since before its inception and have throughout that time spent a substantial part of my practice working on health privacy issues as they have expanded. After the legislation became law and after the rules were being drafted at Health and Human Services, there was something called administrative simplification, which is one of the great ironies of healthcare regulation, the portability and accountability part of HIPAA. And if you look at the title, you'll see that privacy isn't in there. This was a law about portability and accountability. But there were concerns that this portability, which was going to be largely electronic, would result in violations of people's privacy. And so there was an addendum, if you will, referred to as administrative simplification. So portability and accountability ran to less than 200 pages. Administrative simplification ran to almost 800. And there we have the privacy rules that were the beginning of HIPAA. It has morphed in ways that nobody envisioned. Many years ago, then Senator Larry Craig from our neighboring state of Idaho said something that I think perfectly encapsulates what happened. Senator Craig said this about HIPAA. He said, "What began as a tiny kernel of legislative intent has grown into a towering tree of regulatory complexity." And that's perfect because we are still expanding like crazy. And that's really why we're here today, because there has been so much in the past 12 months going on in the world of not just HIPAA, but of health privacy more broadly, that it seemed appropriate to bring that to all of you. I recognize that as I looked at the list of people who were signed up, it was a preliminary list, and recognizing that this is also an alumni association gathering, it is likely that many of you, if not most, don't practice primarily in the healthcare space. And so I have made some informal adjustments to keep that in mind, but I beg you, if I start using terms that aren't familiar, please say so. So I've talked about HIPAA and how that came to be. In 2009, we saw the second piece of major legislation, the Health Information Technology for Economic and Clinical Health, typically referred to as high-tech. The law was passed in 2009 and really didn't take effect in fullness until 2013. The regulatory turtle proceeds at a very slow pace. So we have those two pieces of legislation. We'll talk about specific provisions, and it's not necessary for most of this presentation to distinguish whether we're talking about something from HIPAA or something from high-tech. Much more recently, we have provisions of the 21st Century Cures Act, which in some cases have taken effect and in others will be taking effect. With respect to institutions providing care for mental health patients, we have separate regulations that have always been there and have evolved, the so-called 42 CFR Part 2 regulations. And not terribly well kept secrets, but often ignored, are significant provisions in OSHA regulations and in our educational regulations. I also want to mention a couple of things that are terribly important that I won't be talking about in specific today. First, the European Union General Data Protection Regulations. If you have clients who are doing anything related to healthcare data that crosses international borders, you are probably going to be needing to look at the GDPR. It is much more specific than HIPAA. It's more expansive. The penalties can be more significant. And yes, you are covered by it It might be something as simple as having a website that advertises in Europe. And think about how broad that reach might be. And then the second thing is the most glaring example of state legislation. It's still evolving, but it is law, the California Consumer Privacy Act. This imposes some very specific requirements on any business that's doing business in California, as long as you exceed a certain employee threshold. And so, for example, if you're an insurance company, if you're writing health insurance in California, then you're probably covered. There are three areas of regulatory requirements that are sort of umbrella terms for all of the things that these various laws address. Privacy is, of course, the oldest. That's the original HIPAA. The security rule is a separate rule, and that's evolved quite a bit. That is in the initial HIPAA legislation, and also more specifically in the recent high-tech legislation. And then breach notification requirements were expanded a great deal through high-tech. What this essentially all means is that privacy is about doing things that make sure that nobody who's not supposed to see healthcare information can see it. Security rules are more specific to protecting the information itself from outside and inside attack. Those are in three general categories. One is the administrative rules. That's essentially policies and procedures. The second is physical safeguards. If you've ever been to the doctor's office and you've waited in the waiting room and somebody said, "Mrs. Jones, Dr. Smith will see you now." That's an example of a physical security issue. Is it possible for other people in the waiting room to know who you are, why you were there, or perhaps to be able to see a computer screen? And then the third issue under the security rule is technical safeguards, and that's the cybersecurity stuff that I know nothing about, except that I do know what protections you're supposed to have in place. And then the third area of regulatory requirement is for breach notification. This is a set of requirements that covered entities, in other words, those people who are providers or health plans or information technology service providers, have to meet with respect to the discovery of a security incident which constitutes a breach. That has really two tracks. One is notifying people, and the other for incidents which affect more than 500 people. You have to notify the Secretary of Health and Human Services, and you have to publish things in newspapers locally, and that's a much more burdensome set of requirements. I've worked with and dealt with all of these, and have found that no two are alike. I've dealt with breaches that involved one patient and breaches that involve several 100,000. The issues are the same. Pardon me. Notice my University of Utah mug. Thank you very much. So who enforces all of these regulations? There are some heavy hitters here. Of course, the Department of Health and Human Services, but the regulations are also enforced by the Department of Justice. There are certain violations of HIPAA that are criminal. The Department of Education gets involved in regulating any kinds of healthcare data held by academic institutions. The Department of Defense, because health data is widely held for people in the military and for certain civilians. So, for example, if you are dealing with a Department of Defense issue and it's a civilian contractor, then there are separate regulations there for healthcare data. The Department of Labor, of course, enforcing OSHA regulations. And those, by the way, are not new. I wrote a piece, I think in 2005, about the OSHA regulation of protected health information. And then more recently, the Federal Trade Commission has become very heavily involved, particularly with respect to advertising claims that are made. A very recent FTC action, which is directly relevant, was taken against a provider of essentially cell phone apps that could be used on other personal devices. And the FTC took an action because these apps were advertised to be HIPAA compliant. And so if you have a client who's advertising anything as HIPAA compliant, please see about 25 red flags going up. The HIPAA standards are technology neutral, they are technology agnostic. There are certain technology providers whose products are HIPAA compliant, but be very careful if you are making that claim as part of advertising, because the FTC is looking very aggressively at those things. So that's a little bit about what we're looking at, the universe of things and who's in charge of them. I want to just give you a little bit of a sense of the things I want to talk about that are new. And as I said, there is a great deal that is new. Of course, there is COVID-specific information which we can discuss, but I also want to look at some recent enforcement trends and the kinds of things that we are seeing the government focusing on. And so, spoiler alert, you will see a consistent theme throughout the hour of talking about access. Remember, we described HIPAA as being about protecting people's privacy through privacy rules or through security rules, and letting them know immediately through breach notification if those protections have failed. It's probable that as an industry, healthcare has become too focused on privacy and too worried that disclosures are going to lead to enforcement actions. The result of that has been that patients or their personal representatives have experienced great difficulty in obtaining information. And as you unpack the security rules, you'll see that the idea of security is not just to protect from intrusion, it's also to be sure that that information is available when needed by providers or when requested by patients. So an essential component of all of this legislation is underscoring the right of access that people have to their information. You have, in a very real sense, an almost absolute right as a patient to demand that you be given your healthcare information. And so providers who are not doing that at all, yes, there are some, or who are not doing it nearly fast enough, yes, there are quite a few, are going to face enforcement action. And some of what we're talking about here in the 2020 Notice of Proposed Rulemaking is really about that. Time permitting, I want to talk a little bit about the use of the False Claims Act to enforce health information technology related issues, because all of this umbrella very much includes people developing products to facilitate coordination of care, to facilitate the exchange of information. So with that said, a few quick words about specific regulatory relief for the COVID-19 pandemic. That's come primarily from two places within the Department of Health and Human Services. The Office of Civil Rights, which is in charge of HIPAA regulation specifically. I will repeatedly refer to OCR. I'm referring there to the Office of Civil Rights. And the Centers for Medicare and Medicaid Services, which I will refer to as CMS, because they are in charge of regulating everything that has to do with the rules governing payment for healthcare services. I want to talk very briefly about three specific pieces of regulatory relief from the Office of Civil Rights, and not go too far. And let me just say as a prelude, these enforcement discretion announcements from the Office of Civil Rights and the waivers from CMS are temporary measures. And with a little bit of latitude, for which you will forgive me, here's a generalization. They will expire when the public health emergency is declared over, or if that's declared too close to the end of the year, depending on the waiver or the enforcement discretion announcement, within about 6 months after the declaration. So just keep that roughly in mind. These things are good only until the end or shortly after the end of the public health emergency. So three big changes from a HIPAA perspective to telehealth. This notice of enforcement discretion is essentially to allow almost any kind of health call through a non-public facing platform. So you can't do it on YouTube, but there is great latitude for anything that is generally considered not public facing. In general, if this is the good faith provision of telehealth, it's probably going to be okay. And it's not just about COVID. Providers and patients can connect for any medical reason over telehealth during this particular transition. And again, I'm only looking here at privacy relaxation. There are many other relaxations related to telehealth with respect to reimbursement and to licensing and to the location of the patient and the provider. There is a huge amount of energy going into telehealth right now. I suspect that many of those things will continue post-COVID because telehealth provides so many opportunities to people who find access to care difficult normally. And we are proving over and over that this works really well. And so I think we're going to continue to see this. April 2nd,
Robert,
yes.
can I interrupt you there for a second?
Please.
So when we're talking about telehealth and privacy issues, I'm assuming that a provider would not be liable if a patient chose to use a telehealth opportunity in a public library.
I think that's correct. In another situation, in a non-COVID situation, that certainly would not be true. One of the challenges for provider liability is the extent to which the provider is aware of or has any control over the setting in which the patient is located. But more broadly, the telehealth waivers for privacy and those on the CMS side don't specify the location of your non-public facing platform. So if you're doing a Zoom call with your provider, that's a non-public facing platform. If it turns out that you're doing it in the public library, then that's probably not a great idea, but these rules would not allow I don't think the Office of Civil Rights could take an action against the provider under these circumstances. What a great question. Because so many people might only have access to the internet through a library setting. And so it's really a different perspective on the value of telehealth. Here we're talking about primarily business associates. These are people who are not covered entities, but provide services to covered entities. And because the initial waivers didn't affect the business associate, this allows them to also use and disclose information. For example, you might use a vendor to store all of your health records on the cloud. That vendor might get a direct request from a public health authority. This allows them to respond to that request.
All right, let me ask you another question. What if a physician takes a photo or records the appointment for medical purposes? Is that allowed under the emergency? And could that be something that will go away when the emergency is over?
That's a great question because it touches on a different aspect of the traditional HIPAA rules. There are provisions that allow providers to photograph and to record, but it requires a separate consent from the patient to do that and has to specify the circumstances under which the provider will retain those things in the record. There again, we're looking at a lot of interdisciplinary issues here. So for example, what constitutes the provider's medical record? For what purposes are those records retained and for how long? And that gets into payment issues. It gets into Medicare rules. It gets into risk management rules from the perspective of your civil malpractice carrier if you are a provider. So there are lots of dimensions to that. But the short answer from a purely HIPAA perspective is that you are okay to do that right now. And this is another thing that you've really touched on, something else that I see all the time in my practice, and that is so many things that come to me from people who think they have only a HIPAA specific question actually touch on a much broader panoply of legal issues. And so we so often have that first conversation in the context of, well, you're right that there are HIPAA issues, but you have all sorts of other things that you need to touch on here. So that's, thanks, Lori, I appreciate that. Very quickly, this is an interesting one. This was an enforcement discretion notice with respect to community testing sites. And you can see this, I'm not going to read it to you, but I highlighted a few things here that we thought were really interesting. When HIPAA was being written in the late 1990s, nobody was thinking about how it applies to setting up a tent in the parking lot to provide health care. And so the privacy issues became, in a sense, the epidemiology issues, adequate distancing, and an appropriate use of barriers, but also making sure there's a buffer zone so media can't be there. And I love this one, the prominent posting of the Notice of Privacy Practices, which is something, if you've ever been a patient in the past 20 years, you've had someone offer you a Notice of Privacy Practices. But here it's to prominently post that at the drive-through testing or vaccination site. And when I went through those sites, I didn't see anything except where do I go? And so there we have it. Quickly, telehealth waivers, just looking at some of the things here in which I just wanted you to be aware of these, because although this is about payment, it touches on the same kinds of things, and CMS is trying to coordinate very carefully the payment waivers with the privacy waivers. There will be not a judgment day, it's not that extreme, but there will be a look back. So for people who are exercising waivers, for Part B services, those provided by your physicians under Medicare, there's going to be a phase 1 and a phase 2. I skipped phase 1 because it doesn't matter here, but these are the things that are going to be audited in phase 2, and I've put an asterisk by the things that have direct HIPAA implications. So Lori, to your question, what's the originating site? In other words, where is the patient? Home, in the public library, where? The distant site being the provider. Check-in services, electronic visits, remote patient monitoring is expanding hugely. The difference in remote patient monitoring and your Zoom meeting is that the remote monitoring literally collects and provides clinical data and sends that back to your healthcare providers. And of course, the technology for telehealth, everything from the literally studio quality hospital-based systems to the cell phone that you have somewhere on your person as we speak. And these are
about that leads into the texting. What about texting platforms?
Yeah, it very much leads into those, and there are lots of issues. I've had a number of clients for whom the issue they came to me with was, we've developed an app to allow patients and providers to chat with each other via texting. How do we do that? In the non-COVID world, there are lots of restrictions, and there's an awful lot of ink that's already been spread by the regulators, by commentators, and by some of the enforcement, I say regulators as those who write the rules, and then the enforcement regulators who are also concerned about that. So it's going to be very interesting to follow that and see where it goes when the HIPAA restrictions are relaxed. One of the big issues with texting is that everybody's cell phone has different kinds of protections. I use mine for work, so it's impossible for me to use it. I've got so many protections on there that if I look at it, it turns itself off. And most people don't have all of that. And so if you have children at home and you put your phone down, what just happened? Well, you all know what just happened. So yes, that's a great thing. Couple of coalitions I won't spend time on, just to share with you because they're interesting. The COVID-19 Healthcare Coalition, the second one, is primarily about sharing clinical data, treatment protocols, diagnosis and testing protocols. I mentioned that only because some of our local friends here in Utah have been very involved in that. But for our purposes today, the more interesting one is the Credentialing Initiative. And this is about developing technology standards that will enable people anywhere to obtain digital access across the cell phones to their vaccination records for whatever purpose people might want those. So for example, if you're trying to get on an airplane and your particular airline wants to see that you've been vaccinated, can you just pop that up on your cell phone quickly and easily? And the answer is very probably soon. But there are some heavy hitters here. There are others, I just identified these four, who are working on this using the HL7 standard, which is a widely adopted standard for technology. And because we're talking about privacy, here is some infuriating COVID information. And yes, I'm on a high horse here, and every one of you as lawyers should be. This is absolutely inexcusable, the total immorality of too many people Look at this. Hacking is up 42%. These are people who are intentionally taking advantage of the pandemic for personal benefit. And I don't think there's a deep enough hole under the jail for anybody who's doing that. There's my soapbox. Ransomware data exfiltration just in the fourth quarter is up 20%. Now more than 70% of ransomware attacks involve the exfiltration of data. Again, what could be more horrible than you're trying to get help for COVID and people out there are trying to hold the providers hostage? This is exactly what they do. They call the hospital and they say, hello, we've just put a ransomware bomb in your entire electronic health record. Unless you pay us $1 million, we will shut down not only your health record, but every part of your computer system. That's the bottom line. It's absolutely horrible.
So let me ask you this question. If a patient's PHI is disclosed in violation of HIPAA, what rights does the patient have? So if HIPAA doesn't specifically provide a private cause of action, are there other claims that could exist for a patient for a HIPAA violator? What do the patients have any cause of action against the hackers, for example?
That's a really open question. And that is a very, really open question. The short answer has been no. And the reason that's been the short answer is because these hacking incidents are criminal acts. And so it is the state in the first instance that has the right to bring that criminal cause of action. The civil cause of action, it's too soon to see where that's going to go. There may be people who are participating here today who know more about that than I do. But there has been a lot of conversation about bringing civil class actions against those hackers. Part of the difficulty with that has been that they are fairly sophisticated in most cases, and it's been difficult to find them. Who are they? Where are they? How many different countries have they bounced this malware through to get there? And so I think it's early days in terms of those civil actions. But the other thing that you touched on is the lack of a private right of action, which is true. As far as HIPAA is concerned, it is what the patient can do is file a complaint with the Office of Civil Rights. With that said, with respect to individual providers, we have seen around the country a number of civil cases, individual cases brought by patients against providers, in which the cause of action was a traditional privacy violation tort, one of those things that's been on the books forever, simple invasion of privacy or negligence actions. And I mention that because in some of those cases, there has been an attempt not to say that this is a violation of HIPAA, but to say that HIPAA itself establishes the standard of care that the provider should be meeting in a civil context. And so those cases are new, but they're going to be very interesting to follow. And I have some colleagues doing defense work who are looking quite aggressively at what defenses to that might be.
So then that would lead into not necessarily just the hackers, but what if a hospital or a clinic or the medical provider violates HIPAA?
The medical provider, right.
Then that's what.
Yeah, that's right. And again, it's early days for all of this. And so far too soon to say, here's what the courts around the country are doing, because we don't have enough courts that have addressed any one of these issues enough yet that we feel comfortable with what the answer is. But we know they are critically important questions and all possibilities are out there.
But that leads into another question. I'm sorry, I keep interrupting you. Do you feel like you're at an appellate argument? So
I hope I'm not losing. How am I doing, Judge?
You're great. So what if someone is investigating something related, for instance, insurance fraud, and you're trying to prove insurance fraud, but you can't get the information from the provider because they claim HIPAA privacy?
Agencies that are taking action, as well as civil plaintiffs, can use judicial process to obtain that information. There's a complicated set of rules for doing that. There are a number, within the privacy regulations, there are a number of exceptions. I say exceptions, they are really more procedures because it's contemplated right up front that civil plaintiffs may need information, that agencies may need information. On the agency side, we have law enforcement agencies, we have public health agencies, and we have health oversight agencies. There are three completely separate sets of requirements for those agencies to go through. So for example, if you're a civil plaintiff, you have to have filed a lawsuit, and then having done that, you have to have either permission from the patient, or you have to have gone through a set of steps to arrive at what HIPAA refers to as satisfactory assurances that the privacy interests of the patients have been protected. So for example, a court order is deemed satisfactory assurance because presumably counsel for the plaintiff was before the court and arguing the concerns that the plaintiff might have. So lots of rules out there depending on who wants that information and for what purpose. But if it's a legitimate government enforcement action or a legitimate judicial process, that information can in most cases be obtained.
Okay.
So looking at trends, it's going up every year. Look at just over the past the 6 years that we have here. We don't have data yet for 2020 because it's mid-year before the prior year's data is available. And so you see the number of resolutions. This is not complaints. This is resolutions from the Office of Civil Rights increasing dramatically, with the percentage of cases in which corrective action is taken has remained fairly low. So most of these complaints are resolved through either a finding that the complaint didn't have merit or through educational efforts. There are lots of educational efforts. And so when I represent clients who face complaints, fairly often, and I typically work with some of the same people at OCR, we get to know each other, and fairly often they'll say, well, Robert, here's the issue. We need to do some education for your client, but it doesn't rise to a level that requires corrective action, any kind of disciplinary action. So more often than not, we work with OCR to agree that an educational resolution is enough. But the next thing I want to show you is how much trouble you can get into. And we're going to run short on time. So very quickly, this is the most recent publication of statutory penalties, but these are not the penalties that are in force. And that, if you're on listservs, it can really confuse you because you'll see a pop-up that's, oh, today in the Federal Register, we see new penalties. They're escalated for inflation back to the 2013 start date. So for example, the 1.785 million started out as 1.5 million. That's not what the penalties, those are not your penalties. Here are your penalties. This is because in 2019, there was an exercise of enforcement discretion. And for those of you who are not familiar with administrative law and you want to know something about that in the healthcare space, if you only read one case, go back and read Heckler versus Cheney. Because there the court, a little bit frustrated with having to repeat itself, said, perhaps you weren't listening. Agencies to whom an enforcement action is entrusted have really, really broad discretion about whether to take the enforcement action. So that's what's going here. The Office of Civil Rights said, we are going to use our enforcement discretion to not impose penalties that exceed these amounts. But as you can see, and this is a per-click violation, if you have one per-click violation, you could probably get away with a $100 fine if you really are totally innocent. But if you really should have known and didn't fix it, then it gets a lot more expensive. And if you were willfully neglectful and correct when it's brought to your attention, it's still expensive. But if you don't do anything about it when you hear from the Office of Civil Rights, the numbers get really expensive.
So what about the recent case of MD Anderson Cancer versus Health and Human Services, number 19? Do you think that's indicative of big changes to come, or do you think that decision will be significant as it relates to OCR enforcement actions and penalties?
Too soon to say. I have never seen. Well, I'm going to talk about an exception. So everything I say, there's always an exception.
Of course.
As a general
welcome to the law, right?
I know, right? Isn't that the great fun here?
Yeah.
As a general rule, the enforcement agencies are not particularly concerned about what the courts say about what they do, unless there is an absolute shutdown. And we will look at one of those here in just a few minutes. So do I think that that's going to dramatically change the posture of the enforcement agencies? I think not. I think other factors, for example, a change in administration is always significant, because we have a different, with changes in the political perspective of the administration. And of course, all of these agencies that we're looking at here, the boss in every one of those agencies is a political appointee who answers to the president. And so depending on who the president is from decade to decade, we do observe shifts there in enforcement priorities, but I have generally observed that they track the administration's perspectives more than they track an individual court decision, except when the court says you can't do that at all. So I think what's going to happen over the next 4 years will be interesting to follow, because it will represent a fairly dramatic change in philosophical perspective compared to the past 4 years. So it'll be interesting to see where that goes. So there was an audit of what's going on in the world, and I'm going to start speaking a little bit more quickly to get through some things. It turns out that when it comes to breach notification and privacy practices, most covered entities are doing pretty well. So they'll offer you your notice of privacy practices or put it on their websites. And if they know they had a breach, then they've done a pretty good job of telling individuals. Here's what's not so good. And Charlie, I don't know, I'm not seeing the entire slide here. Are you seeing my whole slide and then pictures to the right, or are you covering the slide?
I don't see the pictures, but I see the rest of the slide.
Okay, if you can see the whole thing, then I won't worry about it. So here's the not so good news. Most covered entities fail to have adequate content in their notice of privacy practices. Most covered entities fail to have all of the required content in their breach notification. So remember what they were doing well? They've posted a notice of privacy practices, and they're getting that breach notification out pretty quickly, but it's not adequate. But here's where it gets much more relevant to the rest of my comments. Most covered entities fail to implement the individual's right of access, such as you get your records within 30 days, I don't charge you too much. Most covered entities fail to respect the individual's right of access to their own health information. That's pretty shocking. This is 20 years post-HIPAA enactment. And then most covered entities and their business associates are not doing enough about the security rule. So as a result of that report, the Office of Civil Rights engaged in what they call the Right of Access Initiative. This began in late 2019. I just want to highlight, just skip everything but the black parts. April 2019, the Office of Civil Rights received a complaint. This is elite. It's a one physician practice. I didn't put his name here because there was no need to do that. So they did that educational and technical assistance thing that I just mentioned. October, a complaint came in April, right? The records request was much earlier, long before April. October of 2019, there is a second complaint. The patient says, I still don't have my records. Hard to excuse this, folks. It really is hard. So as a result, the patient did get his medical records, but the provider had to pay a $36,000 penalty.
Well, was the provider relying on HIPAA to not provide the records?
No. Sometimes they do, but that provider just
didn't provide them.
Just didn't provide them. So that was a single provider. Here is Banner Health, and this is all public information. There's web links here. I'm not sharing anything that isn't already public. This is 2 violations at Banner Health. Now, I distinguish that because you might say, well, a single physician in a small location, okay, maybe they don't have enough sophistication, but really sophisticated institutions also get into trouble. Banner Health is a great system down in Arizona. They have great policies and procedures and people who care very much about what they are doing. They really are good people and tried very hard, but they found themselves on the wrong end of 2 complaints. And again, you're looking at approximately 6 months delays here for provision of the records. And while I know that Banner had defenses to that, nevertheless, the Office of Civil Rights found that there were likely violations. And so Banner paid $200,000. This is 2 complaints, $200,000 fine, and agreed to take other corrective actions. And then the third one that I'll share, again, Sharp Healthcare. They're in California primarily, a very large, sophisticated system. And here it was about third-party access, and they did not provide the records in a timely manner, and so they paid a settlement. So this is very serious. The government's taking all of this very seriously. 2020, we have 2 new final rules, one coming from CMS, that's the interoperability. That's all about people being able to, providers, payers, patients, being able to share their information widely. And it requires the development and use of a patient access API. And these APIs are simply apps that allow people to readily access and share information. CMS also imposed on hospitals what's called a condition of participation. There are many of them, long list of things that hospitals have to comply with in order to be qualified to be reimbursed by Medicare. One of those is to share widely admission, discharge, and transfer notices. Again, wide sharing of information for people who are transitioning from one level of care to another. And then something that affects states, and that is that states will be required to send dual eligible data. That's people who are covered by both Medicare and Medicaid. They're going to have to send that in daily to the government. So whether you're a state, whether you are a hospital, whether you are a provider, or whether you are a health plan, you are impacted by this new final rule. And then the Office of Civil Rights final rule, both of these were March of 2020, by the way. More than anything else, implements the information blocking provisions of the Cures Act. I'm looking at my watch because I know we're running out of time.
You're okay.
So, very quickly, information blocking, and think about what's been going on over the past few years. More and more complaints, the audit that the Office of Civil Rights did and what it disclosed about the difficulties with getting information. Information blocking is a response to exactly that. It's talking about, I skipped one. It's talking about frustrations that people face in obtaining their information. In the 2015 report from the Office of the National Coordinator, the definition was knowing and unreasonably interfering with either the exchange or use of electronic health information. And this 2015 report highlighted what a big deal this is. It's widespread and it's deeply frustrating to lots of patients and to no small number of providers. So in the 21st Century Cures Act, the Congress took that issue on. And they came up with this definition: any conduct that's likely to interfere with anybody accessing or exchanging health information, and likely to interfere was interpreted as any reasonably foreseeable risk. And that came through the regulatory process as this final rule from the Office of the National Coordinator. So information blocking, lots of things. So to your point, Lori, is somebody using HIPAA as an excuse? Well, some people were. Some people were saying, I can't send your records to another treatment provider unless you give me a written authorization. That is not required by HIPAA. Some people were saying it is, but HIPAA absolutely has always, from day one, said, if you tell me as your provider that my records need to be sent to another provider, then I am absolutely allowed to do that. There was never any intent to get in the way of that.
What about sending billing information? Are billing records also protected by HIPAA, or are those distinguished from health records?
They are not distinguished to the extent that they are any information that can be attributed to that patient. So certainly any billing information from a provider is protected by HIPAA. But it's always been true that a provider can send billing information to a payer in order to facilitate payment. Again, just like sending information, clinical information, to another provider, you've always been able to do that. But some people, I can't do that. HIPAA won't let me. If you are part of a healthcare system and the patient says, please send my information to somebody in a different system, it's not okay to say, sorry, we only share within our system. That has never been okay. If you can send the records out today when you get that request, doing that 2 weeks later is information blocking. If you've artificially increased the expense, that's information blocking. So you get the idea. And we've talked about this. It's really anybody who's involved in this process. For those of you who are familiar with the HIPAA rules, just be aware very quickly that the definitions here for access and use are not quite the same. Here, it means the ability to make the information available. So it's not talking about patient access, it's talking about requirements. If you as a provider are doing something that means you're not able to make that data available, that's information blocking. And use is about the ability to understand it and act on it. So for example, if someone says, I only speak Spanish, do you have the ability to give me my record in Spanish? If you say, I use a particular format, it's all in English, but it's kind of a different format, but it's inexpensive for me, I'm going to send your information in that format, that's information blocking. There are a number of exceptions to the rule. I won't take time because I want to look quickly at some of these other things. It's not an absolute prohibition, but if you are doing anything that interferes with the patient's immediate right of access, you probably should worry that that's information blocking. So we had a proposed rulemaking that just came out in December of 2020. The information blocking that I was speaking about, that's actual rules. They're in effect. But in December of 2020, we had a notice of new rules which all address patient access. I'm going to go ahead and not pause on each one of these. Just be aware that over the next 12 to 24 months, you're going to see a lot of chatter about this proposed rule. The notice and comment period's been extended out to, I think, to late April now. This is the first extension. You may see another one, but there are a good many things here, many of which address the court's ruling in the SIOX case last year, which the SIOX was about a third-party vendor who stores information for healthcare entities. And there were great questions about the extent to which the Department of Health and Human Services exceeded its authority in expanding regulatory requirements that apply to covered entities, expanding those to these third-party vendors. And the District of Columbia said regarding a couple of matters related to fees and to the format for information, that the Health and Human Services didn't have the authority to extend those prohibitions to third-party vendors. And so what you're seeing in this notice of proposed rulemaking to a significant extent is the government's response to the SIOX ruling. False Claims Act, I don't really think we have time to talk about this. I will just tell you that if you are violating some of these health technology rules that are HIPAA and privacy and security rules, if you are doing things that violate those, you could also be subject to prosecution under the Fraud and Abuse Act. The traditional ones are kickbacks under the fraud and abuse laws. But look at the one in the middle. That's about your certification of your software. What's that all about? I am producing a software product for you, Dr. Jones, and your colleagues to manage your health information in your private practice. And I'm telling you right now that this is HIPAA certified. That's a false claim, ladies and gentlemen, if that certification is relied on by the provider who is certifying to the Medicare and Medicaid people that they are HIPAA compliant. And then functionality false claims. This is about influences to software designers so that providers who get the software will get a particular version of the software that directs their choices with regard to, for example, in Practice Fusion, prescribing certain medications. But these are huge, huge numbers. So I I wanted to stop here because I know we're almost out. So technology trends with privacy implications. I cannot tell you how huge these issues are in the world today. Telehealth has exploded everywhere. I am so glad to see it because it provides so many opportunities to people to have access to care that they never had. This is fantastic. It touches on all kinds of things. I mentioned remote patient monitoring, the Internet of Things. That's going to be huge. And then I will really stop with artificial intelligence because I think we've got maybe 4 minutes left here. This is interesting. People come to the law with all kinds of backgrounds. Lots of people come to law school with backgrounds in English and philosophy. And so some of you may be fans of the 19th century French writer, Auguste Villiers, the Comte de Villiers. I mention him because in 1878, he wrote a novel. It wasn't published until 1888. It was entitled The Future Eve. And in his novel, a very young Thomas Alva Edison, who was actually in his 30s when Villiers wrote his novel, a fictionalized version of Thomas Edison was asked by a friend who was disappointed in love to create a full-size woman. And in this novel, the woman, Eve, was the first android. And that's where we actually get the word android. So if you're wondering about, if you are of my age, you may have watched the Jetsons cartoons and watched Rosie the robot, who was the Jetsons housekeeper. Well, Rosie was a modern iteration of Eve from Villiers' 1888 novel, The Future Eve. And we see Eve now in the second thing here. Perros Seal Pups, Perros the company. These are adorable little creatures who are finding homes with patients in long-term care facilities, patients with dementia. They are cuddly, they react to you. But on the ethics side, there are a lot of troubling questions. Have we told people that this is a real animal? Are these devices collecting information from people without their consent? And then Sophia is actually a full-size android designed to take walks with people and do all kinds of other companion-like things. All of these are fascinating. They are all not on the horizon. They are with us very much today. I think the going price for a seal pup is about $6,000. I haven't checked recently. I don't know what Sophia costs, but she's really pricey. So I will stop there with my appreciation for your indulgence as I have talked incessantly for almost an hour. Lori, thank you for the invitation. It's been delightful. I'll stay as long as people want to chat.
Great. Thank you so much, Robert. I have a couple of questions. Has there been any commentary or changes as it relates to digital advertising where it relates to medical services? For example, an insurer wants to advertise to those people that have high-risk comorbidities to get a vaccine. So using personal health information to sell services or offer services.
It has been prohibited since day one unless you have written informed consent from the individual patient.
Okay. So another question. If a covered entity obtained external data about the patient, for example, financial data that can be used as a surrogate for social determinants of health, is that subject to HIPAA as well? So if a covered entity got external data about the patient, financial information or something else, is that subject to HIPAA?
Any information in the possession of the covered entity becomes subject to HIPAA.
Okay, does that include genetic data collected outside the healthcare context?
Well, so tell me a little bit more when you say external. So tell me a little bit more about that. So clearly, anything that I create, let's assume I'm a physician practice. Anything that I create in my practice, and that includes any information that I gather from an outside source. For example, I send blood work to an outside lab, I get a report back. I send billing data to an insurance company, I get a report back. Any of that becomes part of my record for the patient and is completely covered by HIPAA.
Okay.
It is also true of any records that I get from another provider. Now, your question specifically, are you asking about if a provider goes looking for other information about a patient that's not related to the treatment relationship?
No, I'm thinking it would be related to the treatment relationship. For
Okay.
instance, I go get a genetic test from some independent party to see whether or not I carry a gene for a specific disease.
Right.
And then that genetic information came from an external source comes to you for purposes, to my provider for purposes of treatment. Is that covered by HIPAA then?
Absolutely.
And that would also relate then to, say, financial data. So given the COVID issue, and we know that certain economically disadvantaged populations are having a more difficult time accessing services and accessing treatment and testing and everything. But we get that financial data and it comes into the practice. Is that financial data covered by HIPAA?
Yes. Anything that is personally identifiable, once it comes into the practice is required to impose the full set of HIPAA protections. Now, with that said, early on, I mentioned that one of the waivers was to allow business associates to respond directly to government requests for information. And so within that context, if a public health agency queries a health information storage vendor, sorry, I'm struggling for the right word there for a second. So for example, PsyOx, not that that was the issue in the PsyOx case, but that's what they do. Then these temporary waivers allow them to respond with certain kinds of data sets to the public health entity. That certainly could include that kind of information because the entity has fairly broad discretion as long as it's legitimately related to the public health purpose. So to your point, identifying people, whether it is demographic information, whether it's purely financial information, who are in areas that may be in need of enhanced services. So for example, one of the things in the recently enacted $1.9 trillion program was money that was earmarked for providing increased services in areas in which people do fall into those categories you mentioned. And identifying those areas accurately couldn't be done through traditional SMSA mapping. You need more information. And so I think that's an example of what you're talking about, and that's allowable under these waivers. Post-COVID, we'll have to see where that goes.
So, but are they making a distinction in collecting that information between overall demographics versus specific individual information? Or can they also release the specific individual information?
It would be difficult to see how an individual, well, let me say that a different way. I would assume that in most cases you would use data aggregation rather than provide individual information.
You're just shooting from the hip.
I'm so totally shooting from the hip. But thinking about those public health purposes, where the public health purpose is to address communities that are disadvantaged. And it is absolutely a huge issue in COVID. No question about it. There's just no question. The data is overwhelming and deeply troubling. But data aggregation, in every sense that I can think of, would be adequate for the purposes of directing immediate public health policy with respect both to testing and to providing vaccine services. I don't know why an individual's information would be necessary for that.
Because at the beginning, there was a huge issue about tracking and tracing. Right. And not tracking and tracing, specifically if it was an app on your phone, would violate HIPAA.
Well, no, if you have consented, which is part of the as you engage one of those apps, you're clicking a consent box somewhere, and so you have consented to share that much of your information with not just with the state, but also with the service provider for the app. And that's where it's that middle piece that has created a great deal of concern. What's that service provider doing with that app? And how do we feel comfortable that they're not doing anything with your individual information?
So one final question. You talked about the potential rule changes that should be watched over the next 6 to 24 months.
Yeah.
Do you think those rules are precipitated by the pandemic? And do you think they'll last beyond the pandemic?
They were absolutely not precipitated by the pandemic. If you and no absolutes in law, except I just gave you one, right? But think back to the genesis of this concern, the right of access issues and the information blocking issues. Those were all in that 2015 report from the Office of the National Coordinator to the Congress. The 21st Century Cures Act, which mandated the March 2020 final rules, both from CMS and from OCR, that was in 2000, legislation passed in 2016.
Okay.
And the extent to which the 2020 Notice of Proposed Rulemaking, the extent to which that is responsive to these very recent developments is not really to COVID, it's more to the District of Columbia decision in the SIOX case, which limited the ability of Health and Human Services to require that third-party vendors cooperate with patient access just as much as the covered entity. So it's really, I hesitate to say today that it's not about COVID, because everything is a little bit about COVID. And I think you will see, when you look at the changes from these proposed rules to what we see in the final rule, I have no doubt that we will see things in the final rule that have been modified, have been tweaked. That's a technical term for us regulatory folks, tweaked, because of COVID. But I do not think that that was in any meaningful way the genesis for the 2020 Notice of Proposed Rulemaking.
Right. Well, Robert, thank you so much. I mean, this was fascinating, and everyone freaks out about privacy, right? But we really don't have as much as we think. So
we do not have nearly as much as we think. And more troubling, maybe, is that when it comes to something as absolutely personal as our healthcare information, we don't have as much access as the law intends us to have.
Well, you're right. That is much more troubling.
Imagine I'm a patient, I have an absolute federal right to my record. I ask my doctor for it, and 9 months later, I still don't have it.
Right, right. Well, thank you so much for doing this, and thank you so much for carrying this by yourself. Please give Bill our best wishes, and
I will.
I hope he recovers quickly, and I hope to see you at a future panel. Thanks, Robert.
Be my pleasure. Bye-bye.
Bye, everyone.